Hello students, welcome to Legacy IAS Academy. In today's video, we are going to discuss about Post Office Act 2023 that has just been enforced like 3-4 days back in India. This act has replaced a British era act. So we are going to discuss in details what is the key provisions of this new act and why it has been facing and drawing a lot of criticisms, especially from the opposition parties in the parliament. Now let's try to understand about this particular act in more detail. So first of all, to give you a brief background about this particular act, it was basically the act came into force on June 18th of the year 2024. That means just we can say 2 days back. It can be passed in the Rajya Sabha as well as Lok Sabha last year in the month of December within a gap of something where we can say 2 weeks. And the act basically repeals 125-year-old act that was referred as the India Post Act enacted during the British time. And in the new act, the provisions that has been included, the major provisions that has been included is to intercept, that allows the government officials and central government to intercept, open or detain any item and deliver it to the custom authorities if need is felt. Now let us try to understand about this in more detail. So first of all, let us understand that why there was a need felt to replace the age-old act, that is India Post Act. So basically the purpose of this enactment was to consolidate and amend the law relating to post office and their governance functioning in India. In this context, now the need for change derives from the basic fact or basic reasoning that the India Post Act that was enacted around 125 years ago, that time the main objective of the post offices was to deliver the letters from one place to other place. However, in the modern context, the post offices offers many other services to the citizens of India, not only restricting themselves to the simple mail delivery. Thus, the primary concern of the Indian Post Office Act of 1898 is no longer valid or is very limited in the current times. Second, what we can say, the post office network has grown to a gargantuan size, and today it has become not only as an interface for delivering and receiving and exchanging parcels and messages and letters, but also it became a very important vehicle for delivery of different types of citizen-centric services. This can be the payment of bill, and similarly these all changes and the growth of India Post, also coming up of private courier industries and companies, especially since 1980s, necessitated the repeal of the older act and enactment of a new law. And that is why the recent bill, the post office bill, and the post office bill was passed last year and the Post Office Act has been enacted. So basically this act now focuses upon the transformation of India's postal services, keeping in mind the present demand of the citizens of India. Now let us look at the important provisions of this particular act, the key provisions of this particular act. So first we can discuss is section 9 of the Post Office Act. Under section 9 of the act, it now allows the central government that by notification it can empower any officer of the central government who can intercept, open or detain any item that has been sent through the India Post Office. Also, the region on the basis of which this thing can be done is on the basis of threat to the state security, national security. If the sending or exchange, or basically we can say if any items that has been sent by Indian Post has a risk of deteriorating the friendly relations that India enjoys with the foreign nations, public order, maintenance of public order, we can say, any kind of emergency situations, exigencies, public safety or contravention of other laws. That can be example, custom laws, the sending or exchanging or what we can say exchange of any kind of, let us say, drug items are prohibited as per custom law. So obviously if you are sending some drugs, prohibited drugs via India Post Office, it is in contravention of custom laws, and thus the officer is empowered to intercept, open, detain it and then send to the customs for further verification. Apart from that, the act also allows the post officers to hand over postal items to the custom authorities on the basis of two grounds. The first ground is obviously if the mail is suspected to contain any prohibited items, that can be commodities such as gold, silver. It can be we can say fake Indian currency notes, or it can be any kind of drugs and other prohibited items, or such items are liable to duty, and the post officer and the concerned officer believe that the required duty has not been paid on the concerned item. So if these two conditions or any of these two conditions are met, the post official authorities are allowed to send the item or hand over the postal items to the custom authority. So that is the main important provisions of the act contained in the section 9 of the act. Now, the second important provision that has been enumerated in the section 10 of the act, that largely provide exemption from the liabilities to the any officials of the post office. Now, this is also one of the area where a lot of criticism is being this we can say a lot of criticism government is drawing for this particular section. Now, what this section basically say, that the post office or its officer are exempted from any liability in case of loss, misdelivery, delay, or damage to the items that you might have sent via or via the Indian Post. So, in course of any services provided to the post, if loss, misdelivery, delay, or damages happen to the articles, to the items, to the parcel, then no liability can be we can say can be imposed on the post office or the post officers, except such liability as may be prescribed later on in the particular. Second, it also has removed all the penalties and offences that were contained under the 1898 Act for the post official authorities. Now, this can be example can be misconduct, fraud, or theft that has been done by the post office officials. So, they will not have to pay any penalty, or these offences will not be penalized. And this is again a big area of criticism that has been included in this particular act. And the last provision that we can discuss in the key provision is the act removes center's exclusivity. Now, this was practically removed already since 1980s, but theoretically we can say by law it has been removed in this particular act. Basically, what it means that earlier, if you look at the older act, so in the section 4 of the 1898 Act, it only allowed the central government an exclusive privilege of conveying by post from one place to another all the letters. Now, important keyword here is all letters. And the private courier companies that began to spread in India since 1980s and grew exponentially in 1990s and 2000, they have been able to already, we can say, overcome these limitations by terming their content as parcels, baggages, packages, and articles. So they say that since they are not transferring or basically exchanging any kind of letters, they are sending parcel. And this law applies only for the letters. So that is why practically it was no longer anyway center did not have any kind of exclusive privileges, but now theoretically also this privilege has been revoked. Apart from that, it also regulates now the private courier services, because private courier services in India especially have grown at least to a very large extent in last 20-30 years, and they are comparable. We can say if you combine all the other courier companies that we have in India, more than 10 to 12 major courier companies are there. If you combine their volume, then obviously the post office have very strong competition from this sector. So there was a need to regulate the private courier services, and that is why those companies have also been brought under the ambit of this particular act. Or also in last we can say it has widened the ambit of the law, and thus to intercept and detain any postal articles as opposed to just letters as were given in the particular law of 1898. So these are the major key provisions that we can enumerate in this particular act. So the question comes that why criticism is being launched on this particular act. So several members of the opposition parties, especially Shashi Tharoor, when the bill was being discussed in the parliament last year, he had vociferously criticized the bill, saying that despite the new bill promises to update the colonial law, to get rid of the colonial law, but at the same time, the recent bill also has kept all the draconian provisions that the 1898 Act has contained. So basically, what we can say practically, it has not removed the overall, what we can say, the colonial law or the restriction that it imposed on the post offices and post office related services. Now, on what grounds we can understand that criticism has been launched? So first of all, the criticism is on the basis of violation of fundamental right that this particular bill and act can have on the people of India. For example, as we have discussed in the beginning of the session, there is no procedural safeguards against the interception of the postal articles. That means anything that you are sending by post can be opened up, can be inspected without any safeguard, and thus it violates the right of privacy of an individual who is sending certain articles, items, parcels, and whatever. And in this context, even if you look at the judgment that was given by the Supreme Court, Honorable Supreme Court of India, we can refer to the judgment of year 1996. The case was People's Union of Civil Liberties, PUCL, versus Union of India. And in this context, Supreme Court has noted that a just and fair procedure to regulate the power of interception must exist, which many critics argue is lacking in this particular bill. So that is the first point of criticism. Further, if you look at the provisions on the basis of which a particle can be or an article can be impounded or can be basically opened up and captured. So there, if you remember in beginning, we have discussed a provision that has been given is the emergency provision. And in this context, the Law Commission of India, when it was giving its recommendation, Law Commission of India of 1968, it has clearly stated that while examining the 1898, it observed that the term emergency is not explicitly defined anywhere. That means it is solely on the discretion of the official that whether this requires or this warrants emergency situations or not, and thus gives a very wide ground for interception. And thus it has been retained in the present act. Apart from that, public emergency, which is a valid ground for interception, is also something that Law Commission has said it cannot be a constitutional permissible ground for the interception of letters or articles. So both emergency provisions as well as the public emergency clause, both of these are something that again is drawing criticism, as Law Commission has recommended or had recommended against it. And last we can discuss is the exemption that has been provided to the post office as well as the post office officials from any kind of liability in case of loss, theft, damage that happens to the post articles. So here also it is in contrast with the law that is applicable to the Indian Railways. If you talk about Indian Railways, it also is a major carrier of many large size particles and all these kind of things, large kind of articles and packages and all this kind of thing, parcels and everything. So their railway officials do not have any kind of exemption from liability. If any damage happened by the railways during the transportation of any particular item, then obviously there is a provision for it to be addressed. However, this is something that is completely missing in the Post Office Act. And second, we can say the offences and penalties that earlier were imposed or could have been imposed on the officials, it has been completely removed. So this is something, for example, if someone or some post office officials have illegally opened the parcel despite absence of any kind of grounds or the clauses that is mentioned here, in that case there can be adverse implications as the right of privacy to the individuals have been violated, and it also will not attract any kind of sanction against this official by the government. So this is something that is worrisome. Thus, what we can say in the conclusion, that in the year 2017, a historic judgment that came in the Justice K.S. Puttaswamy, retired Justice K. Puttaswamy and another, versus Union of India. And in the year 2017, under this particular judgment, the Supreme Court of India had said that the right to communication is a right to privacy. And right to privacy is something that is protected by the Constitution under Article 21. So, any kind of interception, opening or illegal opening of packages that a person has sent via India Post after trusting the India Post is something that violates the right to privacy, and thus it endangers the freedom granted to a citizen of India under Article 21. Thus, what we need to say or what we can say is there is a need or urgent need for incorporating robust procedural safeguards before the right to privacy of individuals is violated under the garb of Post Office Act 2023. That is all for this particular video. Thank you very much.